To understand why this case exploded the way it did, you have to look at what Hawaii tried to pull after the Bruin ruling. While the Supreme Court made it clear that states couldn't hide behind MIAS issue systems anymore, Hawaii went in the opposite direction and built something even more restrictive. They created a rule that flipped the entire meaning of public carry. You could only carry on private property if the owner gave you explicit permission ahead of time. No sign, no approval. Then you were automatically breaking the law, and Hawaii wasn't alone. California, New York, New Jersey, Maryland. They all watched the Bruin decision land, nodded politely, and then drafted laws designed to get around it instead of following it. They didn't eliminate permits, they reinforced them. They didn't expand public carry, they squeezed it. They rebuilt the same walls the Supreme Court had just knocked down, only taller and wider. But Hawaii's version crossed a line even the Ninth Circuit struggled to defend with a straight face. And when the lower courts upheld it anyway, something snapped. This wasn't just another dispute over fees, training rules, or paperwork delays. This was a state turning permission into the entire core of the right itself, the exact opposite of what Brain said. And that's why this case hit the Supreme Court differently. For the first time since Bruin, the justices were staring at a law that openly challenged their authority, dared them to respond, and created a split between circuits that couldn't be ignored. Hawaii didn't just push the limits, they tore through them. This wasn't a disagreement, it was a direct confrontation. And it forced the court, they don't exactly sprint towards Second Amendment battles, waving a proud banner. Usually, when a state builds a restrictive permit system, the DOJ is right there defending it with a stack of legal arguments about public safety and administrative necessity. But this time, they stepped in with an entirely different tone, and everyone noticed. When Hawaii's catch-all property ban reached the Supreme Court, the DOJ didn't rush to rescue it. Instead, they looked at Bruin, looked at Hawaii's ask permission or you're banned rule, and essentially admitted, yeah, this isn't defensible anymore. And that alone would have been newsworthy. But they went further. They told the court outright that Hawaii's law wasn't about property rights at all. It was engineered to quietly suffocate carry rights. They even pointed out that trespass laws already give property owners all the tools they need, so why create a default ban? Because the goal was restriction, not safety. Then came the real shock. The DOJ formally asked to participate in oral arguments on the side of the challengers. That is not normal behavior from the federal government. When the country's top legal office voluntarily steps into a case to help dismantle a permit structure, it sends a message that ripples through every courtroom in America. And just when states thought the earthquake couldn't get bigger, 26 states joined the fight. Not 2, not 5, 26. Red states from every corner of the map filed briefs supporting the challengers, arguing that Hawaii's model was unconstitutional on its face and a threat to national consistency. This wasn't just backup, it was a political and legal show of force. With the DOJ flipping the script and over half the country lining up behind the challenge, the battlefield changed overnight. Hermit-heavy states just went from confident to outnumbered. At the center of this entire battle sits one deceptively simple maneuver. Hawaii tried to rewrite the concept of permission itself. Instead of the traditional rule where you can carry unless a property owner tells you otherwise, Hawaii flipped the script and said you can't carry unless someone goes out of their way to grant explicit approval. It turned the Second Amendment into a permission slip. Picture how backwards that feels. It's like the legal system suddenly transported adults back to childhood, forcing everyone to play Mother May We Nay before stepping onto property that's open to the public, stores, parking lots, gas stations. The law expected you to assume you were banned everywhere unless you saw an affirmative firearms allowed notice. And lawmakers knew those signs would be rare. This is why people call it a reverse Bruin. Bruin made clear that the right is the default and restrictions need historical footing. Hawaii inverted that idea entirely. The ban became the default, and anyone who wanted to carry had to overcome a wall of silence. Even the Ninth Circuit accepted this framing, stretching history so far that other courts struggled to recognize the comparisons. And that's what set off alarm bells nationwide. Because if Hawaii can redefine the starting point of a constitutional right, What stops any state from quietly erasing carry-rough permission games? Now, the Supreme Court has to decide whether the Constitution allows that kind of indune around a fundamental right. The Ninth Circuit has a reputation. And let's be honest, it's not for being shy about stretching a ruling as far as it can possibly go. But this time, they didn't just stretch Broen. They basically tried to fold it into origami. Their decision upholding Hawaii's permission first system wasn't just controversial. It practically begged the Supreme Court to step in. Here's why. Broen laid out a very simple framework. The right to carry exists and the government carries the burden of proving a restriction matches historical tradition. The Ninth Circuit looked at that, nodded politely, and then wrote an opinion that treated Broen like a suggestion instead of a command. They turned the entire analysis into a hunt for vague historical analogies. And even then, the analogies barely resembled Hawaii's modern law. Worse, the ruling created a direct conflict with the Second Circuit. One federal appeals court said, "You can't flip the permission system upside down." Another said, "Sure, why not?" That's the kind of disagreement the Supreme Court hates leaving unresolved because it means the Constitution works one way on the West Coast and another way on the East Coast. And once you have two circuits pulling in opposite directions, the Supreme Court doesn't really get to sit this out anymore. The justices can ignore a lot, as we saw last term, but a split this clean basically shines a spotlight on the problem. At that point, the court didn't take the case because it wanted to. It took it because every sign pointed to, yeah, you're going to have to clean this up. Hold up for a moment. We've talked about how Hawaii built the system, how the Ninth Circuit defended it, and how the DOJ turned the tables. But the next sections are where the real meaning behind all this comes together. Before we move forward, I want your read on something. Is this the beginning of a permit collapse nationwide or just the first crack in the wall? Your thoughts might match the trend I'm seeing, or they might surprise me. Let's continue. Here's the part most people aren't talking about. The Supreme Court isn't just reviewing Hawaii's law, they're weighing a much bigger question that cuts straight through every permit system in the country. Does the right to carry start with you, or does it start with the government? Because if the answer is you, then every state that built its firearm policies around permission, first, right second, suddenly loses its foundation. And blue states know it. That's why they've thrown everything they can at defending these systems. Once the court draws a clear line, it won't matter whether the state is Hawaii, California, New York, or Illinois. The entire model collapses. And here's what really keeps those states up at night. The court isn't evaluating emotions, statistics, or political predictions. It's looking at history, the same test Broen demanded. And when you look at that history, there's not much support for forcing citizens to ask permission before exercising a right. That's why this case feels bigger than the paperwork in front of the court. It's not just about carry laws. It's about deciding who holds the default power, the citizen or the state. And once the Supreme Court answers that, everything else falls into place. This is the point where the stakes start to widen far beyond Hawaii. Because if the Supreme Court strikes down Hawaii's model, the impact won't stop at the edge of the Pacific. It will roll across the entire country in a straight line, knocking down every state that copied the same strategy after brewing. Hawaii didn't invent this system. It simply made the boldest version of it. And that makes it the perfect test case. States like California, New York, New Jersey, Maryland, and Illinois built almost identical structures, hoping that if they all moved together, the courts wouldn't swat them down individually. If Hawaii loses, the shield they built for one another disappears immediately. What makes this even more tense is the timing. Dozens of lawsuits are already sitting in lower courts, waiting for a signal. Lawyers have paused filings, judges have delayed hearings, and states have been buying time, hoping the Supreme Court won't intervene. The moment a ruling lands, every one of those cases wakes up at the same time, and the states that try to bury carry rights under piles of restrictions suddenly have to defend laws they already know are legally shaky. This isn't a slow, gradual shift. It's the kind of change where once the first domino tips, the rest don't get a say. And right now, every state watching Hawaii knows exactly where they sit in that line. Once the ruling hit, the first people to feel the shock weren't politicians or judges. It was law enforcement. Overnight, departments found themselves straddling two worlds: the old permit system they'd enforced for decades and a new reality where those permits might no longer mean anything. Some sheriffs publicly declared the permit checks dead on arrival. Others kept enforcing them out of habit, terrified of making the wrong call and ending up in court themselves. Prosecutors in multiple states quietly started dropping permit violation cases, not because they agreed with the ruling, but because they didn't want to get sued for enforcing a law that might already be unconstitutional. And while officers scrambled to figure out what rules they were even supposed to follow, gun control groups erupted. Press conferences, fundraising blasts, emergency strategy calls made the whole machine went into panic mode. They know this isn't just a policy loss, it's an existential blow. Their entire playbook depends on permits, delays, and administrative hoops. And suddenly, that structure has cracks running through it. Police are stuck in limbo. Activists are scrambling for lifelines. The ruling didn't just shake the system, it exposed how fragile it really was. One part of the shift that most people aren't talking about, but every state accountant definitely noticed, is the financial fallout. Permit systems weren't just regulatory tools, they were revenue engines. Application fees, renewals, mandatory classes, certification programs, background check, search charges. It all added up to millions each year. And overnight, those dollars started evaporating. States that relied on permit revenue to fund administrative offices are now trying to figure out what those offices even do without the steady flow of applicants. Some aren't waiting for answers. They've already begun cancelling scheduled training sessions and refunding unused fees. And it's not just government budgets feeling the shock. Private instructors, certification companies, and state-approved training contractors are watching entire business models shake. Many built their operations around mandatory courses that are now legally questionable or completely optional. The old system created a small economy. This ruling exposed how fragile that economy really was. What replaces it is unclear, but one thing is obvious. The era of charging citizens for permission slips is ending fast. Now, if you zoom out for a second, this ruling isn't an isolated moment. It's the next link in a chain the court has been building for almost 2 decades. It started with Haler in 2008, when the court finally said out loud what gun owners already knew. The Second Amendment protects an individual right, not a privilege granted when convenient. Then came McDonald, which applied that right to every state, shutting down the idea that local governments could carve out their own versions of the Constitution. Fast forward to Bruin, and the court added the rulebook. If a modern gun law doesn't line up with America's historical tradition, it doesn't stand. This new decision is the logical next step, and it answers a question the others didn't fully settle. Do rights begin with the government's approval, or does the government have to justify every limit it tries to impose? The court finally closed the gap. Permits were treated as a gateway for too long, and this ruling snaps that gate off its hinges. If Heller recognized the right, McDonald spread it, and Bruin clarified it. This decision enforces it. Once the dust settles, the question everyone keeps asking is, what does a permitless America actually look like? The truth is, the shift won't happen in one dramatic moment. It will unfold state by state, policy by policy, as lawmakers scramble to adjust. Some states will update their statutes quickly because the ruling leaves them no room to stall. Others will try to drag their feet, hoping to invent new requirements that feel like permits without using the word. But the legal landscape is different now, and courts aren't giving much room for creative detours. We're going to see lawsuits move faster, pressure build on states with strict systems, and a nationwide push to align local rules with the court's new standard. Training will shift toward voluntary education instead of government mandates. And the entire idea of proving your eligibility before exercising a right is fading out. It won't be a straight line, but the direction is clear. The country is moving toward a world where the right to carry doesn't begin at a counter, a classroom, or a filing window. It begins with the citizen. With all the excitement and panic when surrounding this ruling, a lot of people are asking the same thing. Are firearm permits really disappearing in 2026? The honest answer is this: The ruling shattered the legal foundation that permits have stood on for decades. But the practical rollout won't hit every state at the same speed. Some states are already treating permits as optional. Others are rewriting laws to stay ahead of incoming lawsuits. And a few are digging in their heels, hoping the storm will pass. It won't. The big difference heading into 2026 is that the burden of proof has flipped. States can no longer defend permit systems by saying, "This is how we've always done it." Now they must justify every rule under a historical test that keeps getting sharper with every case that reaches the courts. That means long lines, high fees, and subjective approvals are legally unstable. Are permits ending overnight? No. Are they on the clock? Absolutely. And that clock is ticking louder every month, so that's where we stand. A Supreme Court ready to redraw the rules, states scrambling to keep up, and a permit system that's running out of excuses. The next moves won't be subtle and they won't be slow. They'll decide what you can carry, where you can carry it, and whether permission slips become relics of the past or rise back from the dead in a new disguise. If you want the truth before the headlines twist it, if you want updates without the noise, and if you want to understand these rulings before they hit your doorstep, stay with this channel. And trust me, what comes next is bigger than anything we've covered today. Hit subscribe, turn on notifications, and drop your thoughts below. I read every single one.